And for more on the president's authority to deploy the National Guard in California, I want to bring in now Kim Scheppele. She's professor of international affairs at Princeton University, and her writing about events around L.A. they called our attention today. Professor, it's good to have you with us. I want to start with the basics here. Can a U.S. president deploy the National Guard in a state without the governor's consent?
Well, it turns out that we don't know the answer to that question, legally speaking. So the statute that actually Trump invoked to federalize the National Guard, as we say, is a little bit ambiguous on this point. So what it says is that the president may take the state National Guards, which are under the control of the state governors, and he may use them for federal purposes. But the federal purposes include things like if the local authorities cannot handle whatever civil disorder there is. Okay, so the first question is whether there really was civil disorder that the local authorities couldn't control. And as your previous speaker said, both the governor and the Los Angeles Police Department said, we've got this, no worries, we've got this thing under control. So first of all, it looks like that condition for Trump to be able to do this wasn't met in the statute. And then there's the second thing, which is that the statute also says that when this happens, the orders to federalize, to put under federal control, the state National Guards should come through the governor. And of course, what the governor of California is now saying is that they were never contacted, so the orders could not possibly have come through him. So even though there is a law, and that's what Trump has been using, there are at least two reasons for believing that the law was inappropriately invoked.
And is this about restoring law and order, as we've heard the president say today, or do you see President Trump following a bigger strategy here?
Well, yes, I think there's something much bigger going on, and it's sort of two-pronged. So on one hand, Trump is determined to engage in this mass deportation effort. And what's happened in his first few months is that they haven't been able to find all of these people who are unlawfully in the country at the moment. And so they're upping the ante. They're actually increasing the intrusiveness with which they go into immigrant communities and start looking for people who don't have the proper papers. And this has produced a real pushback. So by federalizing the National Guard, by actually putting in tons of troops and police and so on, they mean to intimidate these communities so that they won't actually push back. So that's one thing. And one thing I should say about the president's order, which not enough commentators have focused on, that order does not mention the state of California, and that order does not say last weekend, which is to say it's an open-ended authority that the president
for all
is
50
invoking
states.
To do this anywhere in all 50 states, right? So this is the worry, that this is really the threat behind this, so that immigrant communities and their allies will not stand up and protest. That's one kind of strand. There's another strand here too, though, which is that I think the president is really engaged in trying to push the edges of presidential power to generate the lawsuits to get to the Supreme Court, where we have a Supreme Court that's now hardwired to expand presidential power to the point where it sort of swallows the rest of government. And so this is a legal challenge that I think Trump was inviting. I think the legal challenge is going to go to the Supreme Court, and the Supreme Court could easily say, it's not up to us to determine whether the civil unrest was going to get out of hand. And the idea that these orders have to go through the governor, merely optional, not required, right? And if the Supreme Court says that, then it means, all bets are off on how the National Guard is deployed.
And so is a deliberate effort to remake the Constitution, not through amendments or legislation, but through executive orders and judicial rulings? That's what you're saying, right? That we're going to amend the Constitution by not amending it, thanks to the Supreme Court.
Exactly. So I think it's important to see this as part of a larger strategy in which many of the executive orders that he has issued since he came to power on January 20th have been executive orders that override statutes, that override understandings of the Constitution that we've had for many decades. And I think what he's doing is inviting the legal challenges. And right now, when the lower courts hear these challenges, the lower courts all tell him he can't do it because In fact, the Constitution and acts of Congress say he can't. What he really wants, though, is to push this up to the Supreme Court, where he has 3 of his own appointees and 3 who were appointed by other Republican presidents. And those 6 seem to be, if not uniformly, then more or less dedicated to the expansion of presidential power. And so that's what I'm worried about, that essentially this is the only way you can amend the Constitution these days is by getting the court to say that the Constitution means something else. And I think this is really a constitutional revolution.
A constitutional revolution and a legal path to perhaps unlimited executive powers.
Exactly. And we've already seen, if you remember last summer, the U.S. Supreme Court dealing with the case in which Trump was about to be convicted of felonies in the state of New York. The Supreme Court, that he actually was convicted of those felonies. There was a question about another case arising in federal courts about January 6th and his role in that. And the Supreme Court said that the president cannot be held criminally responsible for anything he does within the ambit of the presidency. Now, what that really means is that Congress cannot constrain the president with criminal statutes. So then how many other statutes can Congress not constrain the president with? And that's what we're seeing now, is that there are all these cases going up to the Supreme Court. There have been 3 decisions in the last 2 weeks where the court has made preliminary rulings in cases that are on their way to that court. And the preliminary rulings tell us they're all in for the unlimited expansion of presidential power. So that's why I'm thinking this is really a constitutional revolution in the making.
I want to ask you, too, before we run out of time, this lawsuit that Governor Gavin Newsom of California, that he wants to slap on the Trump administration. You know, after everything we've discussed here, I mean, what's the point of the lawsuit?
Well, the point of the lawsuit is that the law, as we've known it until a few days ago, was in favor of the governor. And so, you know, he thinks he's well under his legal rights to insist on the law as he knew it. So then the question is, you know, what happens? And the thing is, my guess is that he'll win in the first couple of rounds of court cases. And for us, I think, here in the United States, watching this constitutional revolution in progress, the question for us is, at what point is the Supreme Court going to say this constitutional revolution has gone too far and we need to stop it? You know, or is the Supreme Court just going to go along with the endless expansion of executive power? I think that's the big question. And the reason why I think a lot of us are jumping up and down and saying it's a constitutional revolution is so that more people join us in saying to the Supreme Court, there's a limit to how far you can go before you destroy your own legitimacy. Yeah. And then we'll see if that court actually cares.
Yeah, as we were saying earlier, how malleable is the U.S. Constitution in 2025? I guess we'll soon find out. Professor, it's good to have you on the program. Exactly. We appreciate your insights tonight. Thank you.
Thank you.